welcome to today's webinar, Current Issues in Cannabis Transactions and How to Avoid Litigation. My name is Kevin Jacoby, owner of Jacoby Law. I'm an attorney specializing in litigation in cannabis. With me is Mia Getlin. Go ahead and introduce yourself.
Yeah, Mia Getlin. I am a transactional attorney specializing in cannabis law since started specializing at the very beginning of 2017. And I am excited to be here with Kevin. So yeah, we're gonna talk about transactions from both sides. From transactional attorney side, what I do to try to help help things go smoothly, avoid disputes, keep things as simple as possible if there ends up being a dispute that is unavoidable, and Kevin will talk about what he sees when those disputes do come up. So first, we're gonna be focusing primarily on Oregon. That's where we both do most of our work. But happy to later answer questions about other states, and also most of this is going to be applicable in other states. But so transaction timelines in Oregon, typically I'm brought in once the buyer and seller found each other and negotiated basic terms, generally what's being bought and sold, whether it's an entire business, substantially all the assets, just a license or somewhere in between, and price, if nothing else. Then we'll draft the transaction documents, negotiate any terms that need to be negotiated still, and sign them. Once that happens, or sometimes while we're negotiating before we sign, the buyer submits an OLCC license application, and the seller submits a change of ownership request, and if the license is moving, a change of location request. The reason we might submit that prior to signing transaction documents is because of the OLCC wait time, which, Kevin, I know you and I both have seen how that wait time increases risk to the transaction and risk of dispute. Yeah,
the longer it takes for OLCC to process an application, the more time there is for a deal to fall apart.
Exactly.
Disputes arise and things get messy.
Yeah, and right now that wait, the OLCC last updated just over a week ago, and they had at that point had a sign change request that were submitted through June 17th. So they're about 3 months behind, maybe a little bit under 3 months behind. And we've also been seeing the last few months.
I will say that is a vast improvement from what we saw earlier this year, and which coincided with the transition to camp in March, where we saw just application process screech to a grinding halt. So, it's 3 month wait time to assignment to an investigator seems like a long time, but that's actually pretty short for this year already.
Yeah.
So
right. And something to be aware of is it often changes pretty quickly. Right before the switch to camp, it was really short. I mean, we were seeing some assigned the same week they were submitted. And then, like you said, I mean, when camp came online, we had a lot of licensing staff that got moved over to dealing with camp. And like you said, it just ground to a halt, which makes things a little tricky with the transactions, both from just a business standpoint and then also from, a drafting standpoint. It's something we really need to be aware of.
And then we've got a comment from Samantha Shelley at Can Experts. Sounds like they recently learned that OLCC is going to start rejecting applications that are not complete. It sounds like prior to assignment, maybe. So So the old days of putting in putting in kind of dummy docs in order to push an application through, or placeholders, is those are gone. You got to have your application complete.
Yeah, and I've noticed a kind of inconsistent move towards this where some of the applications that have been submitted that are not complete, uh you don't hear about it until they're assigned investigator. And then some of them, I had one, it was a pretty minor form, that we just weren't ready to submit when we submitted the application, and they asked for that. They didn't kick the application out of line. They didn't threaten to inactivate it, but they emailed and said, can you submit this before we assign? So it wasn't a big deal, but yeah, from what Sam's saying, sounds like it's going to become a bigger deal. Um, and I know the OLCC used to get a lot of pictures of people's cats uploaded. So I guess that's not going to fly anymore.
Wow.
But yeah, so anyway, we submit the application, and once that gets assigned to an investigator, the buyer goes through the licensing process. Typically takes 30 to 60 days, but again, with the OLCC assigning, big slogs of these sometimes, I've seen some of those take longer, even when the buyer is, doing things timely. Sometimes investigators just take a while to respond because they're so busy. Or an issue I've seen come up lately is we do final inspection. We've done everything we need to do, and all that needs to be done is for the investigator to send for final approval and then to get the little pay now button. And that, instead of taking a couple of business days, is taking 1, 2, and in one case for me, 3 weeks. And none of this stuff is a big issue as long as the parties are aware of it. As long as you don't have a seller that's, getting nervous and saying, oh, well, you said that you were done, but you must not be done. Or a buyer that starts, tells their employees you're going to be in on Monday, or orders inventory, expecting to be able to bring it in. So just something to be aware of. And then once they get approved, we close and seller gets paid. And or starts getting payments on a promissory note if it's seller carry. And yeah, so that's and then hopefully that's the end of it. And if not, then that's, I guess, when they're calling you, Kevin.
Right. So a couple of things I want to jump in on about closing is, I'm seeing a large number of these kind of transactions that either fell apart after closing, or even before close, or transactions that fell apart after license transfer. Um, I'm in a number of cases, it's very difficult for me to pinpoint when the closing occurred because people didn't do the closing documents. They didn't follow the contract. They didn't execute everything. They just kind of, went by the license approval and went along their merry way. But then there's no bill of sale, transferring tangible assets. I've seen one case where there was no lease assignment, so the purchaser did not have a lease. They were acting essentially under a handshake deal with the landlord to just be a subtenant of the seller, which became an issue. But that's going to be less of an issue now, than because that was more a product of when, during COVID, when OLCC was streamlining the applications to try to get through the backlog. They were not making it a requirement that you submit a lease, just that you had the consent of the landlord. So
Yeah,
um
go ahead.
go ahead. All right.
Um,
But yeah, so leaving the and or some closing doc, like executing some closing documents but not others. Any required document that needs to be signed that is left unsigned can give one party or the other an argument that this deal never closed. So if you're the seller and the buyer defaults, and you want to enforce the promissory note, the promissory note it will typically say that payments begin within, on the first day of the month following closing. And you've got a closing document that is required under your APA but was never executed, the buyer can say, this deal never closed and the promissory note isn't enforceable. And then that requires a lot of expensive litigation to sort out.
Yeah.
So go ahead, Mia.
Yeah, so a few things on that. One, quick note on the lease. This comes up all the time, especially now the OLCC is asking for these leases again, and so it's even more important you make sure that the current licensee always needs to be the one with the legal right to access the property. And if you have, sometimes landlords don't get that, or the buyer's going to take over lease payments right away before closing, which has its own compliance issues that you can deal with. But in those cases, like you still need to make sure that the current licensee is the only one with the legal right to access the property and under the lease, and that the buyer's lease is not going to be, that their lease term is not effective until they're approved. And sometimes, oftentimes that's what the intent is. The parties just aren't used to, the landlord's not used to having a lease that has a term start date that's sometime in the future. And you submit that to the OLCC, even if you're doing everything correctly, the investigator sees that and they're going to get a little nervous. And so, be careful about that. And then the other thing with closings, this goes back to just, keeping things simple. I love complex transactions, novel structures. When I have clients that have projects that are going to require creativity or figuring out what's going to work in the rules, but we don't want to get more complicated than we need to. A simple transaction should have a simple closing. Even a complex transaction should have as simple of a closing as possible. We don't need to have unnecessary documents delivered at closing. Over the years, I've kind of stripped some out that weren't really adding much. And to your point, we just sometimes find, we're ready with everything, but we don't have this. Or maybe the parties wanted to save on legal fees and they close without attorneys. Don't do that. But also, if clients are going to do that, there's always a chance they're going to do that, and want to reduce the risk as much as possible. One thing is exchanging attestations that reps and warranties are still accurate. I used to require that in my APAs. I typically don't now, unless I have a reason to. Again, it's just one more thing that I don't think provides a ton of value, except in some transactions, and it's just one more thing that might not be delivered. It's also helpful to ahead of time have the bill of sale drafted, promissory note, security agreement, all of that. And so, so I think that helps a lot with reducing the risk of ineffective closings or incomplete closings. Another thing is, is requiring the entirety of the purchase price, or at least what's going to be paid at closing, to be in escrow at some point before closing. Usually we'll do, have it be triggered by the application being assigned an investigator. This typically would not be non-refundable. If the transaction falls apart, even if it's due to buyer breach, usually there's going to be a non-refundable deposit, and then this additional amount would still be released to the buyer. But that way we know the money's there, and we're not going to have, the really messy issue of the buyer gets approved, pays for their license, gets granted their license, and then the seller says, "Where's my money?" and the buyer doesn't have it. Because if we've got the money in escrow ahead of time, or if we're required to put the money in escrow ahead of time, then we have time for the seller to say, "Hey, where's that money? Hey, buyer, here's your notice of breach and demand a cure." And
Yeah,
if the buyer doesn't, you can pull back that change of ownership request, and you might still have a dispute. You might end up in litigation, but at least we're not also trying to get that license back, because the seller's still going to have that license. Because if once the license transfers, once the buyer gets the license, I've had seller clients who say, "Well, we'll just tell the OLCC." OLCC is not getting involved in that. The OLCC is not going to transfer the license back because there was a breach of the contract.
right. That's so there's a couple of points I want to make here. The part of the change in ownership process involves the seller submitting some change in ownership form. Although I'm not sure how it's done in camp now. I think it's an amendment.
That's an amendment button.
But yeah, you submit a change in ownership amendment and and link it to the buyer's application number. That is revocable by the seller at any time prior to the buyer getting approved and paying for the license. So you want to structure your transaction in a way to ensure, if you're the seller, that you've got assurance that whatever money that is due at closing is there and able to be paid. Because to your point, if the buyer pays for their license, receives the license, and then all of a sudden says, "I don't have the money to pay your deposit, let's renegotiate," the seller has no more leverage.
Right.
So it's incumbent on sellers to make sure all of their ducks are in a row and ready to close prior to well before, or make sure the buyer is ready to close once you get about 30-60 days after assignment. Actually, once you hit 30 days after assignment, you should really be checking in and making sure that the buyer makes the deposit or puts it into escrow.
Right.
And if the deal does fall apart after OLCC approval, that's a one-way ticket to court.
Yeah.
Or arbitration. So
Yeah, and so because we're not, you're not saying that, well, if you didn't do this, seller, you're completely out of luck. You're just saying, if you didn't do this, seller, you're going to be paying a little more money in litigation, in attorney's fees for litigation to get
right.
to get your license back, and whatever other damages you
Either
have,
get your license back or get paid.
or get.
Any of that. And the other point I want to make is to your point, Mia, is that OLCC's application process for the buyer is completely independent of the terms of your contract. They oftentimes the investigator will ask for it, but they don't. That's just checking a box. They don't actually review or care whether how that buy sell process is going on.
Right. They care that the buyer is licensable, makes it through the process and gets approved, and that the seller submitted
And
the
the
change
seller consents.
Yeah, and that the seller's license then gets canceled when the buyer gets their license. And
So yeah, and then the other point is, if the seller believes that they need to revoke their change in ownership authorization, because they feel that you feel that the buyer is breached or is not prepared to close, you got to make sure that you follow the termination procedures in your contract. Because if you don't strictly follow those termination procedures and you withdraw it, guess what? You have breached the contract and you could be liable for damages. So,
right.
so follow the contract.
Yeah, be cognizant of timelines. And that's, more things with drafting. you have to be really careful with those timelines and those deadlines. You want to allow, keep in mind, there's going to be that cure period. And if you have a 30-day cure period and the buyer has to put the rest of the purchase price in escrow 30 days after getting assigned an investigator, and you're probably not paying, the client's probably not paying me to send the notice of, to draft and send a notice of breach and demand to cure literally the day that the deposit's not in. I'm typically saying, well, hey, let's reach out, because you don't need to pay legal fees for me to draft a letter if it's, oh, we sent the wire, but we sent it after the same day cutoff, unless we do have that time crunch because of the cure period. But, you have that kind of timeline, and now you're at serious risk of the buyer getting approved before the cure period's over. And yeah, to your point, then the seller has to decide, do I just let this go and hope that they pay, or that they don't get approved before the end of the cure period? Or do I revoke my change of ownership and now I'm in breach and gonna have a pretty hard time curing that without creating damages for the buyer if the buyer does cure? You revoke that change of ownership, and then the buyer cures their breach. And now, maybe the OLCC will pick that application right back up, and maybe they'll say, get back in line, new change of ownership. So that's an important one. Some other things, oh, go ahead.
So just jumping off that point, if the seller revokes their change in ownership authorization, that gives OLCC immediate grounds to deny the buyer's application.
Mhm.
And they probably will, because they're concerned with getting through these applications and making decisions as quickly as possible. And if there is a denial criteria, they'll just deny it. In which case the buyer, if you're if you're in the buyer's in negotiations with the seller to reinstate the change in ownership, the buyer's going to have to put in a whole new application and wait another 3 months. So that's a problem.
Yeah.
So we have a question from Alex Tinker. Any tips, best practices, specific lessons regarding situations where an aggrieved buyer or seller continues to or begins exercising actual control over the operation during a dispute regarding the transaction? That's a good question. So I think we could probably talk about services agreements in that context.
Yeah. So services agreements. Services agreements. Well, first of all, what looking at the attendees, I think most, if not all, probably know what these are, but just to be safe, this is management services agreement. I call them services agreements because you're less likely to get an investigator getting upset about it if you just take management off. Figured that out a handful of years ago. But this is when these can be used in different circumstances, different situations. But in the context of transactions, almost always these are used when the buyer wants to start operating in some capacity prior to the closing. These are fraught, risky for two main kind of buckets of reasons. One is compliance. You can't have somebody with direction and control over the licensed entity or the licensed business, and prior to them being approved to be on that license. And they also can't have a financial interest that rises to applicant level. So 20% or more money that they're getting out of the business, also triggered by paying for a lot of the expenses of the company. You're paying rent, you're paying utilities, stuff like that. And so, for the compliance risk.
And also, if I may add, if that person is either overcompensated or undercompensated, there's the definition of ownership interest kicks in, and they're considered an owner.
Right.
And that's always fun to figure out what is not overcompensation and not undercompensation.
Exactly.
So,
Yeah. Or what the OLCC is going to think is over or under. Right now we've had for a little bit of time, and we will for at least a little bit longer, a way to significantly reduce the compliance risk for this. And that's because changes of business structure where you add an applicant, but you're not doing a majority or total change of ownership, those can be submitted and become effective 5 business days after they're submitted, as long as the OLCC doesn't, say, wait, hold on, no. And so what we can do is add the buyer as an applicant on the license, before they start operating under the services agreement, and then they can have direction and control. They can be acting as an applicant. But the OLCC is planning to go back to the old way, I'm going to say pre-2019, maybe pre-2020, where that's going to need to go into the queue, be assigned an investigator, and be approved. So once we go back to that, it is really important that that the current licensee is in charge. The current licensee is overseeing operations. The current licensee is the one getting the financial benefit, or paying the expenses of the business. And there's ways we deal with this. We can hold the money in the business to be released at the closing, to the buyer. We can do promissory notes to allow the buyer's money to actually pay for expenses. There's rule compliant ways to do this, but it is really easy for the buyer and the seller to kind of slip into the buyer taking a more active, and more of a control role than they should. And then the other bucket of risks is just if there's a dispute. I mean, if you have a transaction fall apart when all that's happened is there's been contracts have been signed, a deposit's been paid, application's been submitted, and change of ownership's been submitted, it's usually pretty straightforward. You're probably not even usually seeing that. I'm usually talking to the other attorney, and we're releasing the deposit to the seller, and everybody goes their own way. But if you have a services agreement, I liken it to being in a romantic relationship that's breaking up. If you're just dating, not going to be that painful probably. But if you've moved in together, maybe bought a house together, gotten married, have kids, have pets, the more of those things, the more you've invested yourself in this transaction, the more painful that's going to be, and the more there's going to be to fight over. And in the services agreement, that comes up a lot with buyers paying for stuff. And if we're lucky, the transaction terminates and the seller says, hey, look, you got my whole crop ready for the year. This is great. Yeah, I'll pay you for what you put in. But more often the seller's saying, yeah, I didn't really want to run this anymore. I get no benefit from this. And then I'm saying, hey, Kevin, here's my client, help him out.
Mm-hmm. And there's, I think every cannabis lawyer has some kind of war horror story from a cannabis transaction where the buyer took over operations. And in fact, I could probably count on one hand the number of times where there wasn't a problem. But and and the number of times where there were problems is rather infinite. So the risks are very high for services agreements, for both for compliance risks are very high, extremely high, if it's not done right. And it's very easy to not do it right, because the client's instinct is to just, all right, we inked a deal, now I take over. That's not how it works. And but the other issue is, like, for example, if you're selling a retail location, and the buyer wants to take over and start running things and pocketing the money and paying the taxes on your behalf, well, you have to really trust that person to pay those taxes, because if they don't, you're going to have to pay it, and you may not have the money. You're not going
And
to
you
have
don't
the
get to
money.
tell the Department of Revenue, oh, hey, no, look, I've got it. And I have this come up with some frequency where a party will say, well, but they indemnified me. Yes, you still need to sue them. And if they don't have the money, you don't, that doesn't bind the Department of Revenue, just like your asset purchase agreement doesn't bind the OLCC. It only binds the parties that are bound by the contract. I will say, the vast majority of the services agreements I've done have turned out fine.
That's good.
Yeah,
Well,
yeah.
because of the lessons learned.
Yeah, most of them, the large majority of them do not end up in front of you or somebody else, but they always make me nervous. And, uh, where I've seen it, to your point, you say, people, well, we signed this, we're good, the contracts are compliant. Um, and, I think there's a little bit of a sense of, well, how's the OLCC going to know? Well, they show up for an inspection and ask an employee, hey, is Kevin, the licensee here? And the employee says, who's Kevin? My boss is Mia. And they're like,
Hmm.
that's weird. Mia's an applicant on the buyer entity. Why don't you even know who Kevin is? Stuff like that. And then they start digging in. And so, and sometimes maybe things are being run compliantly, but now you're going to have a really close look on it because that employee didn't realize that, yeah, maybe they report to me, but I'm not making any decisions without talking to you. And
Mhm.
so, even if you're doing things right, you can end up with some problems there.
Right, because okay, even if you're doing everything right, but an inspector comes in, does an inspection, and gets an idea that maybe that there's an undisclosed ownership interest issue here because of the buyer's involvement. Guess what happens to the buyer's application? It gets put on a compliance hold. Um, and that can be, in my experience, years
Yeah.
before it gets worked out. They're going to do an entire investigation, and if they believe that there's a violation, they're going to send a violation notice to the seller.
Yeah.
And it's going to be a proposed cancellation.
Yeah.
And at that point, the deal has effectively fallen apart. Unless you can get through a contested case unscathed, which is very, very difficult to do. So,
And to that point, that's, something that should be in contracts, drop dead dates. Um, and for anyone who doesn't know, drop dead date is the date by which, if the transaction hasn't closed, either party can terminate. Sometimes, there's limitations. Usually you can't terminate if it's your fault that it didn't close. There might be other exceptions. But this is important because if you do have something, most often, if a transaction's not going to close, there's going to be a breach or impossibility. There's going to be some other trigger to terminate. Not always. And so when those not always situations come up, if one of the parties wants to stay in the transaction, you could have a buyer who's stuck with their deposit in escrow indefinitely, or a seller that's stuck, unable to sell this business to somebody else indefinitely. But again, we need to be cognizant of changing OLCC timelines. You don't go, oh, the OLCC is assigning applications super quickly right now. Let's put the drop dead date 3 months out, because that could super quickly, like it did earlier this year, stretch out, and now you've got a drop dead date that's come and gone, maybe before the buyer's even been assigned an investigator, and then both parties are hoping that the other one doesn't decide that they want to terminate because of, say, the value of the assets has gone up and down, up or down. Do we want to, while we're talking about that, value going up and down, let's go a little bit more into those risks that come up between signing and closing. Do you want to talk about some of the things you see?
yeah. Well, the most common one that dispute that pops up is when this when the seller needs to renew.
Mhm.
Um, so and if your contract doesn't deal with renewal, it, either assigning the responsibility to seller to pay for it or buyer to pay for it, a lot of times I'm seeing sellers that are like, no, I want this deal done and just get it done now. Why do I have to renew? Because it's, I'm not even operating. But it is, obviously it's important to renew because you need that license in existence for it to be transferred. Um, I am seeing, because I get most of these disputes on the back end, and mercifully I'm seeing this issue dealt with, but it in the if it's not dealt with, then it all very frequently becomes a problem, and it became a problem in several cases this year,
Mhm.
um, for that reason, because of the backlog earlier this year. So
Right, and especially when, if you have a seller that's successful and, selling a profitable business, that's probably not gonna be a problem, but a lot of these sellers
very rare.
out of money. Yeah. And also, selling, if they're selling the entire business, you could have material adverse change. The longer the period between signing and closing, the more likely there is to be just a reduction in the value of the business for maybe due to market conditions, which may or may not be accepted from the definition of material adverse change when we're talking about a trigger to be able to reprice or can for the buyer to reprice or terminate the contract. Also, in these you almost necessarily have a seller that wants out. So are they, if they're still operating their business, are they operating it as well as they always have? Are they keeping their inventory levels as high? And, or are they causing a material adverse change? If the buyer's operating under a services agreement, what does that mean for material adverse change?
The buyer causing a material adverse change.
Exactly. Good reason not to, make sure clients need to make sure that their attorneys know, have all the details of the transaction, have occasionally, um, you know, I'll see with some frequency, especially as market conditions have been have been tough, reusing contracts. Maybe the seller has the purchase agreement from when they bought the business or the license that they're operating, and so they want to just reuse that for the new transaction. And that might work all right. The problem is the parties often don't know what they don't know. And so you could have something like, maybe you had a material adverse change provision in that last contract. And now in this one, the buyer's going to operate under a services agreement and they cause the value to go down. And you haven't contemplated that. The buyer can now get out of the contract after they've damaged your business. As long as, if they didn't, and they might not have even breached in causing that material adverse change. Also drop dead dates. Maybe you had a drop dead date 6 months out because of what the timelines look like during the last transaction, and now the OLCC is taking 6 months to assign an application. So that's and again, making sure the attorney knows all the details of the transaction, because and if things change, I've had that come up where I find out that the parties agreed to amend the contract, and they just had a conversation. And if both parties stick to that, great. But if they don't, then now we have a problem. Because, if that's not in writing, and even if it is in writing, they might not have contemplated other effects that had on the contract. So I don't know how often you see that come up where you're getting a dispute where you're looking at the
Very,
contract and they're saying, well, but no, we changed that.
yeah, it's actually quite common. I see that where, there's a like I've had cases where the parties agreed at closing to reduce the total purchase price by $50,000. And that was not communicated to anybody's lawyer. But it was communicated between them in emails. So, so then, and then a payment dispute goes, happens down the line. And then all of a sudden that $50,000 is coming back. It's like, oh, you defaulted all the way at closing. So that happens. There's I see a lot of cases where there's there's some negotiation for an extra payment, or a larger down payment, or a smaller down payment that just is, that you can kind of piece together through text messages or emails, but it's not, you don't have an amendment to the APA. Not to say that those kinds of deals aren't enforceable, but they're much more expensive to enforce,
Right.
because if you have a piece of paper that has, the change terms and everybody signed it, that's easy. Everybody knows that. The
And those
lawyer,
typically aren't very long, don't take that much time for attorneys to draft. I mean, it's
very cheap.
usually with the signature page, probably 2 pages.
Yeah.
Um,
Way cheaper to pay for that, pay Mia for that up front than to pay me on the back end to try to piece it together, and go through the entire discovery and deposition process, in order in order to prove it. But um, yeah, one other question that we've got, that also from Alex, is the is how OLCC handles situations where there's disputes among owners in connection with these transactions. So either active disputes among owners or between buyers and sellers. So I think let's start with an example of, there's a dispute among the owners of a seller over who has the right to control the license and the right to contract. Have you seen anything like that?
yeah, yeah. I worked on one where client had a number of these, but one that I think will also go to Alex's previous questions with a little more detail. Um, one of the owners excluded the other owner from the business for a long period of time. Locked out physically, kept out of the systems and all that.
That's also pretty common.
Yeah, yeah. And so what really helped us on that is that they worked with a litigator from the beginning. So, okay, let me say, so the OLCC, hands off. They, if there's a violation, if what you're saying is, oh, hey, OLCC, this person who isn't even on the license locked me out. Well, they're going to get involved there, but also guess what?
The buyer locked me out.
What?
Like, for example, the buyer locked me out.
Yeah, but also the licensee is probably getting an unapproved ownership violation because you're supposed to be in control. But if it's, hey, I'm a 50-50 owner, or, I own 75% and this other person owns 25%. So they're an applicant, they're on the license, they've got, the right to control it, but they're not letting me in and I have the right as well. OLCC is not going to get involved there. I mean, they'll give you information, they'll let you perform whatever functions with the OLCC that you're allowed to perform, but they're not going to tell the other person you have to let this person in. And they're also not going to let you off the hook for compliance issues. Now, I have gotten the OLCC to be flexible on that. But what it takes is you need to be able to show that you actually really couldn't. And how we've done that is when the one owner was litigating, tried to get an injunction and failed. And so it's like, hey, no, the judge said I can't get in. And so then the OLCC said, okay, fine, compliance issues, not your fault. And the inspector worked with us and said, look, I'm going to come in, I'm going to identify violations. I'm not going to issue any violations. I need to get you into compliance. But typically, you know, if you have, and I've had this come up a number of times where we're saying, look, you know, this licensee, this applicant, you know, was supposed to be, was running it, said they were doing everything correctly, and they lied. And, you know, my client lives, you know, far away from the facility, and or they tried, they were saying, hey, you know, fix this, fix this. They did everything right. The OLCC doesn't care. In fact, in my experience, they get annoyed by that. They're like, yeah, the other guy, it's always the other guy's the bad guy. And so, you know, yeah, the OLCC is going to hold everyone responsible. They're not going to get involved without, you know, without a court order or an arbitrator. Um, and you know, to the extent that there's fighting among owners, in my experience, the response is usually, yeah, you know, welcome to the industry.
Right. I do have one more recent experience that's a bit on topic, that's a bit outside of that. OLCC will be hands off. I have seen, I am dealing with an issue right now where OLCC, where my client was adjudicated to be the sole owner of this license. In an arbitration, it was confirmed in court, subject to a buyout for the minority shareholder, but it was backdated. The court determined he was no longer an owner as of December 31st, 2020. And the arbitrator gave my client the right to either to pay the minority shareholder the buyout, or dissolve, liquidate, and distribute the assets among, you know, proportionately between him and his prior partner. So the client elected to dissolve, and then went to which the other party objected to, which again, they had the right to do it, so not a question. But they preferred that the license be sold so that they could get paid. But in any event, the client went to surrender their license, and OLCC said, no, we're not gonna accept this surrender because you've got this dispute over the disposition of this license with your prior owner. So we're not going to do anything until you get a court order saying who this license belongs to, which is just baffling to me because OLCC's records are clear that it belongs to my client. So, so that's a more recent, like, what the heck is going on there, for me, because you know, you look at the regulations, you look at the rules for surrender, and not accepting the surrender is not an option. Like, it has, like, they can take their time to accept the surrender once the you know, because you've got marijuana on the premises, and they'll do that inspection. But inspection's already occurred, it's no longer operational, and they're just like, nope, we're gonna keep this in limbo indefinitely.
Yeah. So. Yeah. And so we have a question from Brett. The best process for one owner to buy the other out, valuation of the license and business, perhaps. You know, so for valuing a business for a buyout, hopefully the business has an operating agreement or a shareholders agreement that that speaks to that. You know, you know, let's just assume an LLC. Your operating agreement should say if one party wants to buy the other out, what the value is going to be. You know, and absent procedures for one owner to buy the other one out in the operating agreement, you just have to negotiate. Or if you're in a dispute, then again, hopefully negotiate or have a judge tell you. But you can appraise these businesses, and but typically it's difficult. It's often difficult to get kind of consistent valuations on cannabis businesses. In my experience, it's gotten better, but you usually don't want to be going that route. It can be expensive, and again, it can be a little unpredictable.
Mm-hmm. And also one point to note, if you've got if your shares are divided 60-40 and the minority shareholder wants to buy out the majority shareholder, the minority shareholder is looking at having to file a change in ownership application. Or if it's the other way around, it's just a change in business structure. The trigger is a change of ownership of 51% or more.
They will let through if the person's an applicant already on the license. They that's you can bump it up. Another thing for people to be aware of too is the license year. So if you have one owner who's not an applicant is going to take full ownership, and you don't want to have to do a change of ownership, especially because when you do a change of ownership, a new license is issued. At that time, you pay a new license fee. So if last week we renewed and this week we get approved, pay the license fee last week, pay the license fee this week. There's no refund for what you paid before. And so, but one thing you can do is if you're in these negotiations and a minority owner is taking a majority ownership and it's going to trigger a change of ownership, you can, and you have a renewal coming up in 2 months. Maybe what you do is you do this in 2 steps. Get that person's some ownership, but not up to where it's going to need a change of ownership, and then bump it up in the new license year because it's triggered. The change of ownership is triggered by what happens during a license year. Yeah, so that's something to be aware of, and that's something, if a client, if a licensee is having something like that they're dealing with, have a conversation with an attorney or a licensing and compliance consultant. There's pretty simple ways, sometimes not so simple, but worth it for the cost savings to structure these that will keep it a little less expensive.
One other thing I think that's worth noting is is due diligence, particularly for the buyer. One important piece of due diligence is to get the seller's compliance file, so you can discover whether there might be pending charges. Because if there are pending OLCC violation charges that either haven't been noticed yet, or maybe it has been noticed and the seller didn't tell you, that transaction is not going to go through. It's not going to get it's going to be placed on a compliance hold until the seller's compliance charges are either settled or proceed to a final order. So there are there are situations where a seller who is facing violations can sell their license, but that has to be negotiated through the administrative hearings department, has to be approved by the commission, and all of that. So, but if you've got a case where the seller has pending charges and they don't have a settled or a sale surrender approved agreement, then it's going to take, and they want to fight the charges, that's going to take months, years. So,
and that's where drop dead date's important. And also for getting the information and for other reasons, I really like to do in the purchase document, the buyer's required to submit an authorized representative form for the seller's representative, like usually their attorney, or if they, again, if they have a licensing consultant, to be able to get information about the buyer's application from the OLCC, not make changes to it, but get information. And similarly for the buyer to be able to get from buyer's representative to be able to get information from the OLCC about the license. And that it allows the parties to get, like you said, the buyer due diligence, to reach out and get that information directly from the OLCC. If they have any follow-up questions, oh, there is this compliance issue, but it seems pretty minor. Is this going to hold things up? They can ask the OLCC and get that information. It also helps if things are just moving slowly and one party is a little nervous. It really helps to have that, because then you're not relying on each other. The buyer says, no, really, I did all of this. The investigator's not waiting on anything from me. They're just taking forever. The seller doesn't have to trust them. The seller can just go to the OLCC and ask. So.
Okay. We've got one more follow-up question from Brett. And let's clarify, the question is, if it's a minority owner, less than or 40%, for example, is the one being bought out, you would not need to do an OLCC license transfer, correct? But that would be a change of business structure amendment.
Right. Yeah, so 845 OAR 845-025-1132. A change of ownership is defined as, and one of these is a business changing its ownership structure such that the natural persons who did not previously hold a direct or indirect interest in the business will collectively hold a direct or indirect interest of 51% or greater. I wouldn't rely on that. If we're talking about 40% owner, that person would be an applicant. If we're talking about a 10% owner and they weren't disclosed. Also, from what this says, direct or indirect interest, that's any amount. I wouldn't want to fight that. Where I've had the OLCC say, no, you don't have to submit that, is when it's an applicant that's becoming a majority owner. But kind of back to the court order thing too, what I've also found and I think is important to be aware of is, I had a client where they were going into court and two owners were fighting over who was going to be able to control the business. And we thought we might be coming out of that hearing. There were litigators involved. I was not litigating, but with an order saying that one of these owners was going to take control of the business. Well, one of the owners wasn't an applicant on the license. And so that would have been a rule violation. So I reached out to the OLCC ahead of time to find out how to deal with it. And what I got back in writing was, if there's a court order, we'll respect it and we'll deal with any of the issues after. So, again, something to be aware of.
Dealing with the issues after will probably be a notice of proposed cancellation.
Hopefully not, but
that's been my experience with how they deal with any unapproved or undisclosed ownership. And so just be aware of that. Before we wrap up, let's just quickly, I wonder if we can just quickly explain the difference between a business structure change and a change in ownership.
Sure.
Like, as far as timeline processing and how involved it is.
So change of business structure is adding or removing an applicant. We talked before about what an applicant is. And like I touched on, right now, what that process is you submit an amendment through CAMP. And as long as your request is complete and the OLCC doesn't within 5 business days say, well, hold on, no, that is effective after 5 business days. And that new applicant can start exercising the privileges of an applicant. The OLCC, you might have to remind or tell the OLCC about that. I had one where fairly recently where a person was added as an applicant, and then they submitted other change request, and the OLCC came back and said, well, you're not an applicant. We just had to say, oh, look, we submitted this, it's effective now. OLCC said that's fine. However, again, the OLCC is looking at changing that, where that would have to go in line and be processed. I could go on about that. That's going to create some weird issues in some situations, but generally, you know, it's going to go back to where you submit the amendment, you wait for it to be assigned an investigator, you wait for that person to be vetted before they can act as an applicant. It's a little wonky when you are a little weird when you're removing someone as an applicant, but you know, with the change of ownership,
That generally goes to its own queue that goes pretty much faster than the change in ownership, right?
okay, well, that makes me feel better. I didn't realize that. So,
Yeah.
okay, great. And then for change of ownership, it's submitting an application. That's where the buyer's submitting an application. And even if what we're talking about is, you know, say 5% owners taking over 100%. So it's the same business. You're still submitting an application. Buyer's still submitting an application. Seller is submitting a change of ownership. Wait for it to be assigned an investigator. Application gets processed. New license gets issued. And again, that's regardless of whether it's, you know, an arm's length transaction or the current owners are shifting around ownership in a way that creates a change of ownership.
All right. Well, it looks like we are out of time. So thank you everybody for showing up. Thank you for your thoughtful questions. It's very been and thank you, Mia, for joining me. We will be posting the recording of this on my website in short order. So feel free to, if anybody missed it or if anybody has questions. Mia, how can people get a hold of you?
Yeah, feel free to reach out to me with questions. My email address is Mia, that's M like Mary, IA, at miagetlin.com, MIAGETLIN. My website's just miagetlin.com. And my phone number is 503-308-0823. I'm happy to answer questions.
All right. Well, thanks everybody.
Thank you. Thanks, Kevin.